Wonderful speakers today who are all lawyers who are practicing at Tucker Ellis or who had previously practiced at Tucker Ellis. They include Jayne Juvan, Chris Hewitt, Glenn Moracle, and Dan Schiau. They have played a key role in the success of the Business Law Colloquium offered to support upper-level students at Case Western. They have participated in prior years on topics such as corporate governance and Ohio's new LLC law. Today, they are presenting a panel discussion of alternative entity governance and disputes. They will address contractual governance provisions and disputes between minority and majority interest holders. First, a few words about our speakers. There are so many wonderful things I could say, but I will just highlight a few of their incredible accomplishments. So, Chris Hewitt. He began his career in New York at Skadden Arps and came to Tucker Ellis from Jones Day, where he was a partner for 10 years. I like this. As a result of that, Chris brings a big law sophistication to each matter while crafting cost-effective solutions with Midwestern practicality. And he's a fitness nut and goes to work out every morning before work. So, Jayne Juvan. She's also a partner at Tucker Ellis. She chairs both the Mergers and Acquisitions and Securities and Capital Market Practice Groups at Tucker Ellis, a dual role which seems somewhat extraordinary. She's ranked in Chambers USA in the area of corporate/M&A, Ohio. She is appreciated by her clients for her exceptional M&A knowledge, and clients remark that she's a great relationship builder who always puts the client first. She advises clients on mergers and acquisitions, securities, and corporate finance transactions. But what really struck me in reading her biography was that she and her husband, Dan, are both black belts in Taekwondo, and they met in martial arts. So that really struck me. That is amazing. Glenn Moracle. He is now retired from Tucker Ellis, but is still coming back to teach Case Western students. He practiced in the areas of business and finance law, primarily focused on buying and selling businesses, the financing of businesses through private equity, including venture capital, commercial loans, note private placements, public offerings of debt or equity, and other complex business and commercial transactions and arrangements. He's now retired and has more time to pursue activities like scuba diving, I understand. Dan Schiau is at Tucker Ellis, and he is of counsel now. He has significant experience in M&A, finance, and real estate. He wears multiple hats in his transactions, in allowing him to effectively position and advocate in favor of client objectives. Now, most recently, Dan has been named to the list of 2024 Northeast Ohio Smart Business Dealmakers Rising Stars. The program recognized Dan for his high energy, thoughtful, and thorough approach in transactions. That does not surprise me. He was a former student. His ability to add meaningful value to client engagements and his high level of sophistication and knowledge of M&A matters. It was only a few years ago that Dan was a student in this class, and we are grateful that he is coming back to share his insights with the current class of the Business Law Colloquium. With that, I will turn it over to the panel who can take it from here.
Thank you, Professor Kostritsky, and thanks everyone for having us. I will say a few of us have done this the past several years, and it's really exciting to come back to Case and see everyone in this room and kind of speak on topics that we live and breathe every day. And so that's kind of when we were planning on the topic for this year. You know, in the past we did a presentation on Ohio's new LLC Act, and we thought, okay, how can we take that and expound upon it? And one of the things that came to mind was, you know, in the practice of corporate M&A work or securities work, we're dealing more and more today with entities other than corporations, what we'll call alternative entities for the purpose of this presentation. LLCs, partnerships, and even within those two kind of broad topics, you know, there are a variety of sub-entity types. You have special purpose vehicles, you have series LLCs, you have general partnerships, limited partnerships. The list goes on. And so we kind of wanted to talk about the differences between those types of entities and the traditional corporation, how the governance construct can be orchestrated in these entities in a somewhat different manner than traditional corporations. And then also talk about some of the things we see in practice, most commonly the kind of the tensions between different types of owners or shareholders or members, and the different types of disputes that often come up, and how you can deal with them, how you can draft around them, and kind of try and avoid them altogether from the outset. So with that, I guess we'll break it down and start with, the important thing to remember, I guess, at the outset of this is when we talk about different types of entities, we throw around like partnership, for example. There are distinct differences between the legal entity, like a partnership or an LLC, versus what we'll call an entity treated as a partnership for tax purposes. One of the common things I hear a lot, and I'd be curious about your experiences for my co-panelists, but I hear, I ask a client, what kind of entity are you? And they go, oh, we're a partnership. And you say, okay, send me your organizational documents. You get an operating agreement. Those are common things just to be aware of, that there is a distinction. And it's important to, when you're sifting through this, kind of differentiate between, okay, what kind of legal entity are we, and then what is this entity for tax purposes? Because at the end of the day, taxes really drives a lot of what we do.
I think you're raising a good point in that oftentimes clients, and it depends on the type of client, the sophistication of the client, but some clients don't understand any of these distinctions or differences. And so they may think that they're a corp or a C corp, when you get the documents, you find out that they're an actual LLC. It's totally different than what you expected. And as an advisor, it depends with the sophistication of the party. So if you're dealing with a PE firm or a hedge fund, the clients who you're advising oftentimes know the differences. But when you're dealing maybe with an early stage founder or someone who's just new and starting up, then it's very important to walk them through the different types of entity options so that they can choose the vehicle that's best for them. Over the course of my career, I have seen this evolution where we are dealing more and more with alternative entities. And depending on the jurisdiction that you're in, alternative entities are formed either twice as much as corporations or 3 times as much as corporations. And so that's why we wanted to talk about the differences with these entities today, because if you do go into the practice of corporate law, it's foreseeable that unless you decide that, maybe you're doing mostly public company, but that you're going to do a lot of alternative entity work.
Yeah, and Jayne, if I could expand on that a little bit, it isn't as if we only see these alternative entities in the startup company or the family business outside of the public company arena. Because in the public company arena, if 2 public companies are going to get together and do a joint venture, or a public company is going to do a joint venture with a startup or with an individual, it is likely that this joint venture is going to be in the form of, these days, probably an LLC, maybe a partnership. And so even in that public company context, you are likely to need to deal with this type of entity. And one example is in the real estate finance context. There are gigantic real estate businesses that have every one of their properties held in a separate special purpose entity, every one of which is one of these alternative types of entities. Well, generally speaking, they are. And so you might think, in my practice, I'm going to be dealing with corporations. I'm not going to run into these things. Well, you are very likely to run into them somewhere, sometime, somehow.
Yeah, or if you're acquiring a company, the same thing, you're going to be vetting LLCs, LPs,
I think alternative entities is a misnomer, and I'm surprised that it's only 3 or 4 to 1 on the corporations for that, because so there's what, 4,000, 4,500 maybe public companies out there in the United States, and so those are going to be corporations because that's what investors are investing. Last time I looked at this, there's over 4 million privately held companies out there. 4 million. So, and they're almost likely to all be LLCs, if not. So that's why I find the order 3 to 1 off, because it's probably on an order of magnitude of 100 or 1,000.
Secretary of State filings, though.
Okay.
So births are still being filed.
So yeah, but there's some. So the issue is going to be, and Dan somewhat alluded, is the tax driven, right? As to whether or not what you're going to do. If you want maximum flexibility with respect to corporate governance matters, and we're going to get into this in more detail, then you're going to want a limited liability company, because that is considered a contract between or among the members of the LLC, and they can contract to do whatever they want to do with each other. They can completely get rid of, waive fiduciary duties, corporate opportunities. They can get rid of all that stuff. Contractually, they can do that. And then you have the tax aspect of it, which you can elect to treat an LLC tax-wise as a corporation, as a C Corp. So if you want the tax benefits of a C Corp and you want the flexibility of corporate governance, you do an LLC that elects to be treated as a C Corp, and it can even be treated as an S Corp. So you really have to break up between the corporate governance things you're trying to accomplish and the tax things you're trying to accomplish.
Yeah, and going to kind of Chris's point with the flexibility and the freedom of contract and the deference to contracting in an LLC, for example, as opposed to a corporation. If you and for the students, you should, when you have some free time, you can go to Ohio's revised code and look at the corporate statute versus the LLC statute. The corporate statute is by and large more fulsome and strict in what it has in there in terms of, what officers you have to have, how many individuals can serve on your board of directors, or you have to have serving on your board of directors. The list goes on. And if you read that and you compare it to like Ohio's LLC statute, for example, Ohio's LLC statute will, by and large, say, except as set forth in your operating agreement or articles, this is the default rule. And so if you don't have these governing documents that have been negotiated or you haven't put one in place altogether, you can default to the statute, but the statute gives deference to what the members and the owners agree to that's contrary to that.
So let's look at this from early inception of an engagement where a client comes to you and they say, Chris, we'd like for you to form an LLC for us, and we have a handful of individuals who are going to be members. I think it used to be that at least I dealt with this early in my practice, where a lawyer might look at that and say, I can form the LLC and I'll put together the operating agreement. But when we talked about the operating agreement is what governs the entity and sets forth the rights and responsibilities of the parties. And that is a contract, that is a negotiated instrument. And what lawyers oftentimes miss, and for our junior people, if you only take one thing away, let it be this, because it will save you from a possible ethical violation. If it's a negotiated instrument, then there are likely to be conflicts of interest, and you have to decide who it is that you're going to represent in that engagement. Are you going to represent the newly formed entity? Are you going to represent one individual? Are interests aligned such that you feel like you can represent everyone? I mean, I question that, honestly. I'll never forget early in my career working on an operating agreement with a partner. I was an associate, and there were multiple members, and I said to the partner, they were forming a dental practice business, and they were going to go up and do roll-ups, so they were going to acquire other dental businesses or dental practices. And I said to the partner, I said, there's two different members here, and I don't think that their interests are aligned. I think that they should have separate counsel, and we need to decide who we're going to represent. And the partner at the time said, this is just a mere formality. We can proceed. They've known each other forever. They're never going to get into dispute. So we go through, and the partner's working on it. I'm just observing, and I'm like, should I go to ethics on this or not? Which is always an uncomfortable spot when you're a junior baby lawyer. And the partner proceeds to get the operating agreement in place, leaves me out of some of the discussions. And I was flying out to an American Bar Association corporate law event because I thought I really want to understand corporate law and the way that these issues should be tackled. And I get out there, and the operating agreement was inked, and within 24 hours, there was a falling out between the partners. And the partners turned on the law partner who I was working with, saying that he had a conflict.
Which was not Tucker Ellis.
That was not Tucker Ellis. That was not appropriately resolved. So when we are looking at LLCs, we're talking about contracts governing the rights and duties of the parties. And when you're dealing with contracts, those are negotiated instruments where parties' interests oftentimes diverge, meaning that you have a conflict of interest. And you really do need to take seriously who is your client, who are you representing in that negotiation, and is everybody appropriately represented so that you don't end up in that situation?
Just to make sure we're clear, a corporation is a contract too, right? So it is the charter, it's the bylaws, it's a contract as well. Those are considered contracts. The difference is that corporate law doesn't say, there are things in corporate law that says except as provided in the regulations or the bylaws or whatever, but even there's governance on what you can actually do in those documents. So they're both contracts, both contractarian in terms of what you want, what you're doing, but from a corporation perspective, you're kind of just buying into the contract. Whereas for an LLC, you can contour the contract for what you want it to be. So just to make sure that we're not just looking at the fact, hey, corporations are contracts too, but there's a different kind of contracts. You have more flexibility. Yeah.
And usually, oh, go ahead.
Just at the risk of sounding too glib, I have often said that the beauty of these LLCs, for example, or partnerships, is that there's almost an infinite variety of ways you can structure them. The downside for the practicing lawyer is there's almost an infinite variety of ways you can do things, which means there are a lot of choices that need to be made, whether people realize it or not. There are decisions to be made about how this is going to work. I think, and I agree with Chris, more so than in the typical corporation.
Right. So, Mr. Moderator, keep us on task.
I want to talk a little bit about, we've kind of highlighted, we'll get into more detail about the governance differences. I want to talk about a little bit about the liability and the liability shield differences. And when we're talking about it, you have to distinguish between liability to third parties and liability to the other owners in an entity. In a corporation, you generally, from a shareholder perspective, have no liability to third parties. And that's assuming you're maintaining the corporate formalities, the corporate veil, so to speak. Closely held corporations might vary that if you have a dominant shareholder, but by and large, that's the general rule. You move down in a corporation to the board level, and you have directors that, generally speaking, have no liabilities to third parties. And then to their own shareholder base, you have the overlayer of fiduciary duties. In a LLC or a partnership, that can change, and in large part that's due to the ways you can vary the applicability of fiduciary duties, for example, to the owners or members or shareholders, and also the amount by which you can impose additional duties by contract. And Jayne, I know you and I have had conversations on like the undertones of, in an LLC, for example, fiduciary duties and the standard of care concept that a lot of folks jam into operating agreements, for example, and don't think twice about how this is interfering with, the duty of loyalty, for example. Do you want to talk a little bit about that in the context of an alternative entity versus a corporation?
So, from a governance perspective, and Chris, feel free to weigh in, or Glenn as well. But one of the key factors is that, and by that, under general corporate law, you have a board, and the directors owe the duty of care and the duty of loyalty. And I'm sure you've gone over the general fiduciary duty framework in your business association courses. As somebody who's sort of wonky about governance, I honestly love studying that framework. And I think that there are so many benefits that flow from that framework, because I think that it sets an expectation for conduct for the individuals who are serving in those roles. Now, when we move into the alternative entity framework, we have the ability to waive those fiduciary duties and eliminate the fiduciary duties under Delaware law. So in your operating agreement, you can negotiate or agree that fiduciary duty of care and duty of loyalty are not going to apply to the entity. Now, Delaware case law in particular is very particular. So if you are going to waive fiduciary duties, the waiver has to be unambiguous. So you have to be very clear that you're intending to waive fiduciary duties. And there's a whole litany of cases in Delaware where parties may think that they've waived fiduciary duties, but they haven't because they haven't been express about it. Or where, after an operating agreement is inked and there's litigation, lawyers will scrub the operating agreement to show that there's actual language in there that is a waiver, whether it was intended or not. And the court might say in that instance, no, the language used isn't sufficient. I've done some work in the venture space over my career, and venture capitalists in particular find this to be helpful, private equity too, in that they have portfolios of companies where they can have conflicts of interest or be in similar business lines, and are concerned about the legal risk that they have in operating in similar industry verticals, because the corporate opportunity doctrine, for example, if it were to apply, may require that they take corporate opportunities to one vehicle and not divert those opportunities to another vehicle. So there's a legitimate risk there. But with that said, that's I'd say the setup for the elimination of fiduciary duties. Chris or Glenn, do you want to go into it further and what that means?
Well, I guess the observation I would like to make is you have to avoid thinking this is going to be a one-size-fits-all idea, that somehow waiving fiduciary duties is a good idea, or it's a bad idea, or this is the way to do it. Because you think about the differences in the context. Let's say there are two friends who decided they're going to start up a company together, and they had this great idea, and they are going to cast their fortunes into this together. The way they would think about their duties to each other is going to be dramatically different from what the situation is if you have a serial real estate development company. You have a company that develops, let's say, shopping centers all around the country, and they set up all these different investment partnerships and have outside investors invest in each of their partnerships. The relationship between that person, professionally manage an investment for you and you're a passive investor, compared to your relationship to your lifelong friend that you're tying your life fate to, those are very, very different needs in terms of how that relationship will work. And it's not that even in either one of those contexts, there's a one right way to go about it. The fundamental point is you have to really understand the circumstances and what people think the risks are, the risks they are willing to bear, and what their relationship really should be. And it leads to some very difficult conversations sometimes early on in the relationship to get people to really focus, and especially in those circumstances where, let's say it is the two friends who are getting together to do something and they're convinced they will always be the best of friends. It's really difficult to convince them that they need to have a mechanism ready for when things go wrong. I'll share a war story. Literally decades ago, 3 men came into the office and they wanted to start up, this was long enough ago, it was going to be a corporation, S corporation we're going to use. They wanted to start up this entity to operate a restaurant. And of course they counseled them that restaurants are a very risky business, high failure rate, but they were sure they wanted to do this. And they wanted to form this corporation. And I explained to them I was not representing any of their individual interests. I was going to represent the entity, but help them understand what their decisions were in doing that. And one of the things I recommended was you need to have a buy-sell agreement. You need to have some arrangement under what circumstances will one of you need to be removed from the business, and how will that person's interest in the business be purchased, and how do you come up with the value, a price for that? And they say, we don't need that. We've been best friends since college. We don't need anything. I said, humor me. I am your legal advisor. You're paying me to give you legal advice, and my strong legal advice here is you need something like this. Without exaggeration, it was only 6 months to 2 of the 3 came back into the office and said, tell us again how we get that bastard out of here. And they said bastard, so that was the direct quote.
And we've also seen situations where no good deed goes unpunished. We've had situations where there's a successful business person, they have friends, and they want their friends to participate in the opportunities that they've created, so they make them members of their organization, but then don't waive fiduciary duties. And then down the road, one of the people who essentially has very generously been brought into this scenario is unhappy with the way the organization is managed. And if you're not careful in protecting that successful business person that allows those opportunities, those other people to have those opportunities, that person could be facing a breach of fiduciary duty suit. And we've seen situations where those types of individuals have gotten sued and the damages for breach of fiduciary duty have been material, when had there just been more thinking and planning at the beginning on the choice of entity and the governance framework, that person probably could have been shielded from liability exposure.
One other thing I wanted to add too is I often see, in a lot of operating agreements where I'm dealing with opposing counsel on the other side, or maybe multiple opposing counsel if there are multiple members negotiating the operating agreement. The most typical draft I see is one that has a complete and absolute waiver of all fiduciary duties to the maximum extent permitted by whatever state law you're in. And in a lot of circumstances, or some circumstances, that might be exactly the right outcome for all parties involved, depending on what the business is going to be. In other circumstances, if you really know the ins and outs of how these duties work and what you can do, that might be the complete opposite. You might want to be holding someone's foot to the fire if they're going to be in charge of running something and say, no, you're not going to, have side businesses that might compete or might overlap with this entity. I'm trusting you to run this business I'm investing in, and I expect you to do that. And so really knowing your way around this stuff and how the law allows you to, not manipulate is probably not the best word, but use it to your advantage to drive the outcome on behalf of your client, I think is a powerful tool.
Well, one thing is, we're talking about fiduciary duties, and it's fine, but there's other mechanics in operating agreements that let you address those issues while not imposing fiduciary duties on people, which is that you have all your restrictive covenants that are in there. You can't do X, Y, and Z. You can't do related party transactions. You can't hire your family members. Unless you get a vote of people to do that, right? So there are certain things that you have in core, so you can address some of the bigger issues that can suck out value. But part of the issue is that when you have a lot of these LLCs, you have very entrepreneurial people that are doing them, and they're letting people in. And the whole point is that I'm going to decide what I'm going to do with this entity, and here's the structure on it. And then I might do something with a different entity, with other people in the same space, but I want different investors, and that's what they're trying to set up, and that's what you got to be very clear on that. But then you could say, well, at the core, though, look, I'm doing this to form a restaurant that does this, and then you could say, this entity will not do anything besides restaurants, and I won't do any other chicken concept except in this restaurant, right? But I can go do pizza, and I can do tacos, I can do whatever outside. So again, those are the kind of things we're talking about. You got to think about, like, you can very craft this to actually meet everybody's needs so that they're getting what they want at the end of the day. That's fair. You do have the ability to take advantage of people if they don't think through the stuff they trust you. I would say this, okay, when it comes to, and they touched on it, but it doesn't matter what kind of familial relationship you have with somebody, and certainly if you're not family and you're not blood and you don't share DNA, you absolutely have to have protections in your document. Don't ever think that your water's thicker than blood and you can make this thing work. You absolutely have to put these protections in, have shotgun provisions or whatever it is that you want to have in these things. I'm just telling you, never, ever, they can never. Anybody that tells you that, I mean, again, just look at life, right? You have family members hate each other over their views on COVID, for God's sake, right? And it's destroyed families, and yet you think that when you are actually sharing money and economic interests that you're not going to have that happen? That's naive.
Chris, my experience has actually been that family disputes, family-owned businesses, when there's a disagreement, are the nastiest the situations out there. The most difficult, infighting, it's almost like, I know Daddy liked you better, colors the whole discussion, and it's, it becomes even irrational.
It's William and Harry, right?
Well, I'm saying the thing about it, okay, if two brothers form a company, in all likelihood, there's not going to be a problem between the brothers, okay? It's more like that. Okay, but then you get down to the next level, which is the cousins dealing with each other. They can probably tolerate each other to a certain degree. You get down to the second cousins, forget it. Bets are off, right?
The more money there is, the more nasty it gets, I think.
So one example. Well, I would say so I was the trustee of my parents' estate when they passed, and I had 7 brothers and sisters, and I was in charge of running all that. And when it was all done, I did the final distribution. I had them all sign waivers, completely releasing me of all claims they may ever have, yada yada, against me as a trustee. And people are like, well, why don't you trust your brothers and sisters? I said, I absolutely trust my brothers and sisters. I don't trust my nieces and nephews, right? So, again, you have to always think through. It is a game of chess to some degree. Where is the problem going to come from, and make sure that you're drafting for that.
Yeah, but Chris, I think you made a really good point that I want to make sure is emphasized, and that is that there's so much room to customize, and you can be very specific about here's where the space where we're going to play in versus the other areas where we're not going to play in. A lot of it comes down to what is the leverage between the parties and what are you able to negotiate. We do a lot of work with companies where we're on the sell side of a transaction. And in today's market, when a company is selling or trading, the owners oftentimes will stay on post-closing and continue to be in the management team. And if they're selling to private equity, for example, they may want a second bite at the apple, meaning that they're going to roll over a portion of their equity. They're not going to fully cash out at the first closing. And in those scenarios, if we're representing the fund or if we're representing the rollover, the individuals who are in management who are rolling over equity, we look at these operating agreements, and the funds will want to make sure that they're fully protected in those scenarios. And they are writing a large check, oftentimes to the seller of that company who's rolling over. And so when you get the operating agreement for the new co, oftentimes it's very clear. All fiduciary duties are disclaimed. Corporate opportunity doesn't apply. We can put our own interests ahead of your interests. That the operating agreement has even said in certain circumstances. So in that instance, the rollover members probably don't have a lot of leverage in the negotiation, and they're walking away with a lot of money, on the first sale. And so they'll come to us, though, and they'll say, well, this makes me worried. What does this mean? And in that situation, it's sort of like you're along for the ride, right? You're not the one calling the shots. You have no governance rights in this circumstance. We are going to hope that the PE firm does the right thing. But we will look at org charts and all the agreements together to see how can assets be siphoned off or not, and what are the many different ways where you could be shafted as part of this arrangement. And in a worst case scenario, someone who's part of the management team might find that their rollover really doesn't carry the value that they thought it might.
You can almost write the agreement as, trust me. And by the way, you cannot rely on that statement.
And you can't you trust but don't verify.
Right.
You can. But yeah, and with that being said, in any of these relationships, who you're contracting with really matters. And what I say to my clients is, let's run intelligence searches, because for sophisticated private equity, they're transacting all the time. And, if they're bad actors, oftentimes there are indications of that. So I will run intelligence searches of newspaper articles, all the litigation that they've been involved in. I'll go right to the fund manager's name, run them specifically through, we have access to Bloomberg databases that can go pretty deep. And I try to understand, who am I contracting with? Because it's not just a matter of, I went to dinner with so-and-so and I thought they were a good person, because they may or may not be, but what does their history say? Or another approach might be, I want to, and this is maybe less reliable, but I want to talk with a dozen other individuals who sold their company to you to understand how those transactions worked out for them on the second bite. Because oftentimes when I get those deal documents, the rollover isn't an insignificant amount necessarily, but you get the documents and you can be worried about whether the value of that equity is going to hold up or not, and whether those promises are going to be honored.
Yeah, and I'd like to make a broader observation. That is, many times in your practice, you're likely to be in a situation where some behemoth of a company puts a document in front of you or your client and says, this is our standard form, we never change it. tell them to sign this. There's no conversation to be had here. And sometimes that's true, but you don't know until you try. And I have been surprised both ways with times when we took what I thought was an entirely reasonable position and someone wouldn't budge just because, well, we never do that. Or in the other end of that, there have been times when we're dealing with somebody I thought they're never going to change their document for us, but you ask and you're like, oh yeah, that's very, and you get what you ask for. So you don't know what you're going to get until you ask.
Yes.
How would these considerations, including Delaware law, bear upon the Ohio decision versus being establishing the heightened fiduciary duty?
Well, that was the one exception when Dan said generally shareholders don't owe fiduciary duties to other shareholders. There are some limited circumstances where they might, for example, if there's a controlling shareholder who takes advantage of that ability to control to the detriment of the minority shareholders, then courts may impose fiduciary duties on the shareholder for doing that. I can't remember exactly the facts of Crosby being other than I know it's out there, but yeah, the professor over there probably remembers the
Well,
facts.
I don't remember the facts in particular, but I do recall, I believe the expression the court used was that the duty owed by the dominant shareholder is akin to that owed among partners. Well, now we've changed the whole standard of what that means. So I'm not aware of any case law that really answers your question, but I think there's certainly a reasonable argument to be made that the whole notion of, well, we're imposing a standard like what we impose on partners, and now partners can agree that they do not have a fiduciary duty, for example. I think there's a door open there.
So, okay, so we can get rid of fiduciary duties, right? Okay, the governance framework that I love studying is out the door, sadly. How about this implied covenant of good faith and fair dealing? What does that mean?
Are you looking at me, Jane?
Yeah, 'cause
Yeah, it is a non-waivable covenant. Although you can dispense with all fiduciary duties, you cannot waive the covenant of good faith and fair dealing. But it is not, I don't believe that duty is really what it sounds like, because the courts have held that if you have an agreement that expressly provides for a certain outcome, and you are just enforcing that agreement the way it is written, the fact that it feels abusive, feels unfair, feels like you're cheating is not relevant. This is only a duty that really applies when there's some circumstance that was not anticipated, and it's almost a gap filler in the cases I've read of saying when you didn't actually expressly provide for an outcome, you have to behave in a good faith manner.
Okay, so the good faith and fair dealing is not a fiduciary duty at all. I don't understand why people even go down that road. Because the covenant of good faith and fair dealing applies in all contracts. I don't know if you've done contract law or whatever, but it applies to all contracts. And what that simply means, and yes, they say the gap filler, all that simply means is that when you are reading your covenant in a contract as to what you're supposed to do, that you have to act in good faith in fulfilling that covenant. So, for example, let's look at a purchase agreement that has an earnout at the end of the day, right? So you have an earnout that says if you hit X and Y metrics, you get more purchase price. And so the covenant of good faith and fair dealing would say something to the effect that you, buyer, who that might have this earnout, can't act in a way to prevent that earnout from happening. Okay, so you can't say and then divert we're not going to do any sales for the next 4 years to avoid the earnout. Well, okay, obviously that makes no sense, right? So that's what the covenant of good faith and fair dealing is. That when you read a covenant on its face, that you're not acting against the intent of that section of what that provision says. It has nothing to do with fiduciary duties. It's straight up just a contractual concept.
And it doesn't impose a level of morality on anyone.
Well, but the interesting thing, though, is that Jane and I worked on a project, and ultimately we had to disengage from this project around this point because our client was thinking about ways to structure it, and we were talking about the LLCs and no fiduciary duties, And he had this consultant who was a former accountant, as far as I remember, and not a lawyer and not a corporate governance expert, but he was a consultant advising him on corporate governance and telling him that this covenant of good faith and fair dealing was a fiduciary duty, and so that we didn't know what we were talking about when we were saying we can waive off fiduciary duties. And I mean, even so far that JD drafted like a $30,000 memo explaining that that wasn't the case, and he still had his ear. And I said, we just decided this is too dangerous of a situation. We can't have our legal advice being trumped by an accountant who's becoming a consultant who thinks he's a corporate governance person. We're just going to get in trouble. So we disengaged from that client and said, go follow your consultant if that's what you want to do.
And Chris, since you used the earn-out example, I can't resist telling about a situation. I've had this happen a couple of times, where our client was on the receiving end of they should be receiving payments on an earn-out. Didn't happen. And there was some evidence that the party who promised to make the earn-out payments had never intended to make those payments. And I looked closely at securities law. Professor Rack will identify, I think, with what I'm about to say, determined that the earn-out provision was in fact an investment contract under securities law, and that the statements made by the party when they negotiated the earn-out were materially false statements about the earn-out, and therefore there was a securities law claim with respect to the earn-out, which is way outside the topic today.
I know, I was going to let you finish and then pivot back. Mr. Moderator, get us back on course here.
So, since we're running a little short on time, I do want to get to talking about disputes a bit and the types of disputes that arise in these types of situations. And I'll tell a very, very quick story because it ties together a couple points that were raised, which is I worked with a client about a few years ago now that it was two sets of cousins that were brothers, and they owned a set of companies that their two fathers that were brothers founded, and they came to us and said, essentially, we've been fighting for decades and we need help. We need to separate these companies. And the first thing we did is say, okay, send us all the organizational documents of all these companies. Let's see where we're starting from. And where we were starting from was essentially little to no governance infrastructure in place, or certainly not one that was well thought out and structured to avoid a situation where there was a deadlock, and talk about what happened. How do we get out of this situation? We were able to get to a successful result, but it kind of emphasizes all the things we're talking about, which is the need to focus on these items at the outset. And so when I have or deal with clients that come to me and say, hey, we want to have, for example, we're going to do a 50-50 LLC and we're both going to be board members. There's going to be two of us, right? And I go, what happens if you disagree on something? And their answer is typically, we'll figure it out, right? That might be true. I will tell from experience that it more often than not sets up for failure or disaster at least. And so one of the questions I guess I wanted to ask to the panelists, which is, if you're faced with a situation like that, what are the types of things you would be advising a client to try and negotiate for in an operating agreement or a partnership agreement?
Again, my favorite deadlock story was very public. This happened in the last decade. It was a TransPerfect situation. I don't know if anybody's familiar with the TransPerfect situation, but it was a man and a woman who were engaged at the time, formed TransPerfect a long time, 30 years ago, 35 years ago, whatever it was. And they were engaged, and they were going to form this company, and then they decided, even before it kicked off, that, you know what, let's not get married. They broke off the engagement, and yet they still kept their business, so you can see where this is going to go, right? So they split it up 49 and 49, and then they gave the other 2% to the guy's mother. So you're thinking that that's going to break. But so anyway, they get to their deadlock, and the mother basically says, I'm not doing anything. So they're stuck at 49-49. And the woman then finally petitions the Delaware Chancery Court to run an auction to sell off the company. So she's the one, okay, we can't do this, I'm going to sell off the company. They run an auction, and the guy wins the auction. And he's able to win the auction because he already owns 49% of the company, right? So he only has to buy 51%, right? He only has to buy out his former paramour, I guess, and his mother. And then she cries bloody murder. because of the fact that this happened, and the judge is like, I ran a process. He was the highest bidder. What am I supposed to do at this point, right? So that's my favorite story, just because the way it all played out and kind of. But yeah, there's all sorts of different provisions. One that we used successfully for a client was that we called so-called shotgun provision, where if they were 50-50, they had a disagreement. This was in the shotgun provision. At any point, they could try to resolve the issue, and if they failed on consecutive attempts, then one of the partners could make an offer to the other partner of, I will buy your interest for some dollar amount, right? And then at that point, the other partner has the option of either selling their stock at that dollar amount to that person, or buying out the person who made the offer for the same dollar amount. So it puts you under the, like, to make sure that you're making a legitimate offer, because you're not gonna do a lowball offer, because then the guy's gonna say, fine, I'll buy you out at that price, right? And so we successfully did that, and we kicked around with the client about what he was going to offer, and shockingly he put in a lot lower number than I thought he would, and the guy took it. So that's one way, and then they got it resolved. But interesting, on his way out the door, this was our client was the investor, the other owner was the CEO, and so on his way out the door, this was for a coal mine. He actually assigned over all of the mineral rights from the company to himself going out the door. And then, of course, we were like, no, you can't do that. He claimed that as a CEO, I had absolutely the right to do that.
Back to corporate assets.
Like, not the bit that was stealing and embezzling and everything else, but he just argued, as a CEO, I had the right to sign over this stuff.
It is amazing what we see. Another construct that you and I have seen in action is the concept of having an advisory board that if you have two 50-50 partners who own the LLC, they would put in an advisory board. So if they're deadlocked, then there might be an advisory board, let's say of 5 people who would come together and break the deadlock. Others may have seen that play out in a good way. I personally haven't, because what I found in that scenario is, first of all, the advisory board members may or may not be vested in truly reaching the right outcome. Second of all, they may or may not be educated even in overall governance, so that can be a problem if they're not. And then it can be very political. So, one member is trying to take, 2 advisory board members out to dinner one night, the other one's trying, and it all can snowball very rapidly and just become total chaos. So I haven't seen that. And I don't know, maybe an advisory board where you actually have qualifications set out where people have to have governance experience, maybe that would work. But the advisory board concept to me had seemed earlier in my career like that's an interesting concept. Maybe that would work. But in reality, I don't think that that's been as effective as I would have.
Yeah, I agree. The advisory board is like the mother that had the 2% interest in transfer.
Right.
It's almost exactly the same situation. What happens is you say, okay, we're going to put an advisory board, let's say 3 people. So one person picked by one partner, one person picked by the other partner, and then they find an independent. And so how it all plays out is the person picked by you votes with you, and then you still have the deadlock, and then the independent says, you know what, I'm getting out of this. I'm not doing anything. And they don't do anything.
Well, then they get really worried about what is my legal exposure.
Yes, they do nothing. So you're still left in the deadlock.
Yeah.
I think the reality is the 50-50 ownership or 50-50 control situation is almost never something that can work out well. And the circumstances where you have problems are when the business is either failing and people are fighting over the fact, this is going all wrong, and it's your fault, we got to fix it, or it's wildly successful. Okay, if things are going along kind of the way people expected, people are going to get along. It's when there's money being lost or there's money to be made, more money to be made than people expected. That's when the pressure comes on the arrangement. And I have yet to see a situation where a 50-50 arrangement comes out successfully. And the shame of it is if all the focus is on fighting between I'll use the term loosely, between the partners, it means everybody's taking their eyes off actually running the business. And the value that is likely to be realized for the business eventually may well be harmed substantially by that.
Or just dispute over strategy, I think, is the other one that I feel like I've seen. Where, like capital allocation decisions. I feel like I've seen a decent number.
Well, we have a client that we work with that again, and there's a history behind this. Like they started out as 4 partners or 5, however many people that were together, but they also were invested in other entities that they all kind of had a piece of, right? And we sold off that, but we have this one where, and we're working through some operating agreement issues and buying and selling and redeeming people and stuff like that. But he throws out there every once in a while about how well this company's doing. Like they're making money hand over fist at this point, to Glenn's point, and basically at this point, this is the business now that he's taken over and he's running, and it's doing really well. And he's grousing about the fact that have this percentage, right, and everybody else has more than me, and I'm really the one growing all this for their benefit, which is why he's looking to redeem them out and do some stuff. But I hear that and I let it go because I put him on the couch, let him make his complaint, and then. But at some point that could manifest itself because I don't represent him. I represent the entity, and I point out when he's doing this. When he was talking about I said, have you talked to the other members about what you want to do? And are they good with it? And he said yes. And ultimately they got to sign it. They actually have a pretty good operating agreement that anything they do has to be agreed to by everybody to sign it anyway. So and these amendments they have to. But you hear that, and every once in a while he just throws it out there. Yep, they're just riding my coattails. But the only reason he's there is because he was brought in and given an opportunity.
Oh, and sometimes we're standing on the shoulders of giants too. It's that the value creation by the silent members is what opened the door to the opportunity. And is he the one to the next level of success? Yes, but that wouldn't have been possible without the other. They have valid arguments as well. But I think another point, just from an ethical perspective, is that it can get dicey very quickly. You know, if you're taking your instruction from a managing member, so to speak, but you're representing the company as counsel, you have to remember that you're representing the company, and the company's interests may diverge.
Jayne, you made a comment when we were talking before this presentation about private dispute resolution provisions, arbitration, mediation, et cetera, and having I think you have an opinion on the use of those in an agreement like this to break a deadlock or deal with a dispute.
I actually think mediation can be very healthy in a process, and even when I draft agreements, sometimes I'll have, just a collaboration provision or a process where parties will come together and talk and try to work through issues before you go through the process. I am in favor of those, and I also believe cooling off periods can be so effective, because what can happen in these situations is a lot of ego in the room, and people are hot and they're not thinking clearly in the moment, and that's only going to escalate. Have a cooling off period. Oftentimes people do walk away. So those are maybe a little more informal. Practically speaking, they can be so effective. And as a lawyer, sometimes too, you can serve a really good role in trying to bring the sides together to do a deal that is in the best interest of your client. But I think lawyers can serve such an important role if they let themselves do it. Some lawyers won't serve that role though, and just want to fight, right? Which I don't think is constructive. Arbitration worries me, and I'm interested in others. But I have just been through with my clients personal experiences where they've gone to binding arbitration, and the arbitrators really, they're interpreting Delaware law, and I don't think they understand the law as well as Delaware Chancery Court. Have a really bad, poorly reasoned decision binding on the parties, and it could be catastrophic from an economic standpoint. I don't want to put my client in that situation. So I that, and I've seen that's, just because of the seat that I've been in, my view toward that. Do you have?
Well, I think one advantage of arbitration, depending on how your arbitration agreement reads, you have limited discovery, which might kind of streamline the process, and you can have confidentiality that you're not going to have a a court docket that's going to have all this information about your business and your dispute all laid out there. It can be very private, and you can have an arbitration ruling that doesn't actually require any kind of reasoned opinion. It just has the outcome. So if you're concerned about how much of your, not necessarily dirty laundry, but just how much of your business information is going to be out there, I think arbitration can be advisable that way.
Absolutely never, ever do arbitration. We can talk about it. Absolutely never, ever do it. It's certainly never binding arbitration. And the rules of evidence don't apply. I mean, you can have hearsay. It's silly. It's a kangaroo court, in my view. To Glenn's point, I actually think the fact that all your personal information can be exposed in the court is going to drive you to a settlement and a negotiated solution to that problem, as opposed to having to go through the court.
But then if it goes through the court, and I
Then they
want
give
to
it
be in
again.
Delaware, and I want to be in front of the Chancery Court
Yeah.
judges, and if
No,
they
don't
rule
ever do
against me,
arbitration. I'm just not like you.
Okay, you learned that.
Yeah.
Take that away.
Like, if you have an arbitration class here, you should just get rid of that as a class and say you don't do it. Because there's no
Okay,
benefit.
now, we have just a few minutes for questions. So I'm gonna interrupt. And either you pick up one of the questions that you really liked, or we could start with Jane's question for Chris Hewitt on the difference between multi-billion-dollar acquisitions and the smaller deals. Jane, you want to ask your question?
Yes, so I just had a question about how you approach those differently, and aside from like the cost generally, like what differences do you have to prepare for as you facilitate, and how do you use skills from one to facilitate the other?
Well, okay, so I'm going to say something that's going to blow your mind. Big, multi-billion-dollar public company deals can be way cheaper to do than private deals. The biggest wild card in any deal, in terms of the cost, is going to be the due diligence that's done on it, depending on how the level of diligence is put on. Public companies have publicly filed documents that are filed to a materiality threshold that have people with liability for putting that out there. And so it can be much more streamlined. I did a deal a long time ago. It was when Federated, now called Macy's, bought the May Department Stores company. It was a $17 billion deal, and the entire diligence was done in an hour by the two CEOs talking to each other on a phone call. That was it. That was the entire amount of diligence that was done on a $17 billion deal. There's a lot of legal issues about, because there's antitrust issues and stuff like that that had to get worked through, but so they can be a lot cheaper to do actually at the end of the day. And they also, public company deals are, you do the deal, you walk away. There's no indemnification, there's no ongoing liability, whereas private deals all have indemnification now. You're going to have rep and warranty insurance. The representations and warranties matter in a private deal. They don't largely matter in a public deal because they're just closing conditions, right? And they're to a materiality standard, a MAC, material adverse change standard, which no court has ever found to occur. So actually, public company deals are a lot easier to do than private deals.
Well, and Chris, I would add that in the public company deal, you probably have people who are professional deal people on both sides of the transaction. Their legal teams, the business people, you probably have somebody who's in charge of business development at that company, and that's what they do. And these people know how to dance the dance. They know, and they know where the real issues are. They know what has become kind of market. Where it gets really difficult is when you're dealing with somebody whose lawyer is his cousin who wrote his will for him 2 years ago, and he's the only lawyer that guy knows, and he's trying to negotiate a merger transaction or an acquisition. Those can be very difficult.
Based on the common sense that he doesn't have.
So Nathan, you had a question for Jayne Juvan, and it was if you could add one provision. There you are, Nathan. Do you want to ask that?
If you could add one governance provision to every LLC or partnership agreement, what would it be and why?
Well, I would add a board contract because I like the traditional board framework. But setting that aside, what I love is that these agreements actually can be bespoke agreements. And so what I would say the beauty is the ability to customize the agreements to every situation. And so I think the important thing is to really listen to the parties. What are their goals and objectives? And then tailor around that what is going to be effective for them at the stage of growth they're in now. What would be effective if you look 5 years out, as they've grown? How can you possibly marry those two? And we've talked about fiduciary duties, but in the operating agreement, you can set forth other standards of conduct that would fall below fiduciary duties. And I think that's the beauty of the framework that we have, is that you can really work with the parties to determine what is the level of expected conduct that should be required. So for me, it's more just the bespoke nature of it that I think is the beauty in it. I wouldn't put binding arbitration provisions. More like, here's the things I wouldn't do.
Be remiss to talk without going up. My favorite provision that we put in, talk about bespoke provision, was two guys. Again, it started out as 4, right? They each had 25%, and then somebody left, and then another one left. So they were 30 each, and now they're 50% each to this issue. But so they weren't concerned about, again, oh no, we don't have to worry about these. Even though they got rid of 2 other partners. No, we're the best of friends. But the interesting thing, they had a bespoke provision was it had very well, if one died, then the other one took over as the member, and the spouse was just an assignee of the economic interests, and vice versa, right? And so then they were like, well, what happens if we both die at the same time? What are we going to do? And so then you see, well, then they wouldn't have survivors, so you had it back to the spouses would be the members, and then they go, no. No, there's no way our spouses could be the members. So we had to draft a bespoke provision that said in that situation, if they both happened to die at the exact same time, and you couldn't, so what would happen is that the spouses still stayed as assignees, and then they went out and found a representative who would come in and be the member. Which is surprising you can do this. You can have someone who does not have any equity interest in it, can be a member of an LLC. That person came in as the member solely for the purpose of wrapping up the affairs and distributing out the cash to the 2 spouses. So very interesting. So they presented it to us, and then we had to actually scrub through the statutes and actually found that as a solution.
So the provision that I enjoyed drafting the most, though, was a result of my $30,000 memo, which was a really good memo, by the way. But in that scenario, the founder was afraid of his own shadow, and he was terrified of getting sued. And he had other members, and I think that some were family, not all were family. And so what I found was case law where one of the judges said that you can add a provision that says that the party in its sole discretion may consider only such factors as it desires, including its own interests. So it expressly stated, I can act in a self-serving way. And there was case law that supported that approach. So I was like, this is turning corporate governance on its head as far as I'm concerned, because I really believe in the duty of loyalty. But I thought that was one of the more enjoyable provisions to draft.
And Janie, something we haven't really touched on is it's a common approach where there's a majority interest and a minority interest to have a concept called major decisions or some terminology like that. And basically, the majority gets to do whatever they want except for this list of certain things. And they require some kind of special approval. So you can put kind of a governor on things.
Yeah, and I think if I'm a minority member, for example, I want to have a special approval, right, where debt is concerned, right? That if you're going to...
You can't borrow more than X amount unless you get the special approval.
Right. So, so you can slice and dice that way, too.
On that note, I think we're going to have to thank our speakers for coming. There were millions of questions we didn't get to, but anyway, we'll just have to stop it there. And just thank you so much.
Thank you for having us.